And now we'll discuss question number 12. What do you understand by pious obligation of a son with regard to discharge the debt of his father? Discuss. Do you agree with the view that this theory has been diluted by the Amendment Act 2005? So, the very doctrine of pious obligation, as well known, has its origin in the Smritis which regard non-payment of debts as a positive sin, the evil consequences of which follow the on discharge debts even the world afterwards. It is for the purpose of rescuing the father from his torments in the next world that an obligation is imposed upon the sons to pay their father's debts. And here Manu says, money due by a surety or idle promised or lost at a play or due for spirituous liquor or what remains unpaid of a fine and tax or duty, the son shall not be obliged to pay. So unlawful debts by the father are not falling under the doctrine of pious obligation. And now discuss the very effects of judicial decisions on the doctrine. The doctrine as formulated in the original text has been modified in some respect by judicial decisions. So, under the law as it now stands, the obligation of the son is not a personal obligation existing irrespective of the receipt of any asset. It is a liability confined to assets received by him in his share of the joint family property or to his interest in the same. The obligation exists whether the sons are major or minor, whether the father is alive or dead. If the debts have been contracted by the father and they are not immoral or irreligious, the interest of the sons in the coparcenary property can always be made liable for such debts as it was held in the leading case Siddhas versus Buddheshwar in 1943 by the Privy Council. The fundamental rule is that a Hindu son is not liable for debt contracted by his father, which is immoral or irreligious and illegal, dishonest. The facts, circumstances, and contract of the father are to be looked into to ascertain the nature and character of the debts as it was decided in 1979 in the leading case Viprocharan Saboto versus Pauri Saboto. In Nan Bachan versus Sitaram in 1977, Allahabad High Court has held that by virtue of the doctrine of pious obligation, the interest of the sons in the joint family property are liable for debts of their father in a joint family provided they were not incurred for any illegal or immoral purpose. The creditor could legally attach and put up to sell the right, title, and interest of the sons in the joint family property. So, exactly when the liability arises, the son's pious duty to pay off his father's debt not contracted for illegal or immoral purposes is a present liability annexed to both the father's and son's interest in the ancestral property and does not depend on the facts whether the father is alive or dead. The liability of a son to pay the debts of the father is not personal, it is limited only to the son's interest in the Coparcenary property. Since under the Hindu Succession Act 1956, the Coparcenary interest of Mithaq and Coparcenary devolves by succession, not by survivorship in case the female heirs of class 1 of the schedule are present, the sons would be liable for the payment of the father's debt only to the extent of interest inherited by them for their father. Their liability to pay such a debt would not be unlimited. And in the leading case of Nandan versus the Bana of Bihar, in 1977, the Patna High Court held that sons are liable to pay any debts contracted by father before partition unless there was an arrangement for payment of these debts at the time when the partition took place. And in the same way, this view of Patna High Court was supported by Gujarat High Court in the leading case Jayanti Lal versus Srikant in 1980. It has been held that the doctrine of past obligation applies to the debts contracted by the father before partition, but it does not apply to debts incurred after partition. The sons, even after partition, are under past obligation to pay up the debt incurred by their father before partition. And regarding that also, the Allahabad High Court in Nan Bachchan versus Sitaram in 1977 has laid down that by virtue of doctrine of pious obligation, the interest of the sons in the joint family property are liable for the debt of their father in a joint family provided they were not incurred for any illegal or immoral purpose. The creditor could legally attach and put up to sell the right, title, and interest of the sons in the joint family property. And as regarding the very amendment to Hindu Succession Act in 2005, as it provided equal share to the daughters, such as either married or unmarried daughter, but regarding the very past obligation of paying the debt of their father, the act diluted this very theory of doctrine of pious obligation, as the very daughters, whether married or unmarried, they are entitled to an equal share from the coparcenary property or the ancestral property. So it is required that they should also pay up the debts of their father on the very doctrine of pious obligation. So this is the very delusion that was made on the amendment of the Hindu Succession Act 2005